Welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast. And a big hello to everyone in between. My name is Dan Balkaran, and I'll be your employment lawyer for the next 30 minutes or so, answering all your questions about all things employment law. As always, I work for Samfiru Tumarkin LLP, which is Canada's leading employee-side employment law firm. Housekeeping, if you need to get a hold of us, there you go, you see on the screen, that's me, and that's the name of the firm. Housekeeping, again, as always, if you need to get a hold of us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay, so we have half an hour. It'll go by really fast. Please send your questions in now. Quite often what will happen is I get a flurry of questions at the very end of the broadcast, and I really want to get to everyone's questions. So please send them in as soon as you can send them in. Okay. Sylvie says, how many weeks of EI do I have to be on before the company calls me back? Or when do I take it as a termination? Okay, so I think you're conflating concepts here. I think you're on layoff, sure, because you haven't said you're on a layoff or in a medical situation or what. But what your employer can lay you off, and then if you're provincially regulated, you're subject to the layoff period set out in the employment standards legislation in your province. If you're federally regulated, then it would be under the Canada Labor Code in terms of the duration you could be on layoff before you're considered terminated by statute. But what the EI is for is EI is administered by Service Canada. It's a federal government program that says, well, it's a problem for the country if people are out of work and have no money, because then a percentage of them will be unable to survive and will be living in the streets. And so the government will very quickly get you money and then to tide you over during those periods of time when you are between work, we'll say. And there are all kinds of strict rules around your eligibility for EI, how much you're entitled to get in a row, et cetera, and all of that you can look up on the Service Canada website. But the amount of EI you get, and that you're entitled to, is not the trigger for whether or not your company calls you back to work. Your company is going to call you back to work, theoretically anyway, if it has the work for you to do or if it wants to recall you to work. If it doesn't, after a certain period of time, you're terminated by operation of law. So, for example, in BC, it would be 13 straight weeks or 13 weeks out of 20 weeks. If you're provincially regulated, when your layoff would become a termination. And then at that point and why you'd want it to become a termination is then at that point you would seek severance remedies. And remember, as always, severance, depending on what your employment contract says, and then your age, length of service, and position, can be quite lucrative. It can be as much as 2 years, 24 months of severance. So certainly, if you're moving towards that, you're going to want to speak to an employment lawyer. You can do so if you want to get a hold of us at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. But if you are on layoff, Sylvie, you can always inquire with your employer, hey, when are you bringing me back, and see what they say. But it's not clear from your question exactly what's going on. All I can say is your employer is not looking at how much EI you have as a determinant of whether or not it will call you back to work. That's just its own independent question of whether or not it's going to do that. But Sylvie, if it looks like it's not going to, or you're going to end up at a point of treating it as a termination, you certainly want to talk to a lawyer. Question from Jason: how much surveillance is an employer allowed to have in the workplace? Do employees have rights to privacy? This is an interesting question. I will admit straight out, I am not an expert on privacy legislation. There are certain privacy legislation protections that exist for employees. I don't know how those function, and I certainly don't know what the remedies and penalties are. They come up very little in employment law, and so I'm going to have to primarily not answer your question, Jason. I will say, I think this came up in a radio interview I did last year with respect to, it came up with respect to somebody who had, so what businesses will do, you talk about surveillance. Some businesses are doing surveillance of keyboard strokes and, what the content is on your computer. And so there was a minorly famous low value case that happened in British Columbia I think it was last year, where an employee was working from home, as a lot of us do, and she was working. Well, while she was working on her work laptop, she was also watching Disney Plus and Netflix. And the employer confronted her about that and said, you're engaging in time theft. And she said, effectively, and it's been a long time since I've taken a look at this particular decision, but something along the lines of, "You caught me, sorry about that." And the employer then sued her for time theft effectively, and I think got $5,000 or $3,000 out of her or something. And the reason why the media was interested in it is wanted to know if there was a change in the law where employers were going to be able to go after their employees for issues in the workplace. And the short answer to that question was no. But in that case, and why I brought it up, it's not problematic. What the employer was doing there was not problematic. It was logging what she was doing on her computer, right? And especially as you got to look, employment law is really about the concept of employment. Everyone has a job, more or less. Everyone of working age who is in the workforce has a job. Most people aren't business owners. And so all of us work for an entity, but the entity has much more power against us. And so employment law is trying to really determine what's fair between the parties. And as culture and technology changes over time, and as more and more people move from home, I don't think it's unreasonable, and I don't think the courts will think it's unreasonable for employers to want to have some degree, in exchange for working from home, some degree of visibility into what it is you're doing when you're at home, when you're supposedly on the work clock. And so I think that the idea of having keystroke loggers or just general surveillance on work machines as to what you're doing, I think that's going to be permitted. I can't see why it wouldn't be permitted, but I will also tell you that there, especially in a relatively tight labor market, if that's something you don't like, you can always vote with your feet and go work somewhere else. And I imagine that a lot of people will do that when what they're doing is being scrutinized to that degree, to the point where it rises to the level of what you would call surveillance. So, it's a balance, but I can't answer your question about what degree, but I expect that the answer is a substantial degree. Your employer is entitled to know what you're doing when you're on the clock. I'll just say that. And generally, if you don't like it, you can always go work for a different employer. But in terms of the second part of your question, what are the rights and remedies under privacy legislation? I can't help you there. Amelia asks, I was recently let go from my job because another employee said they cannot work with me. It's a bit of a complex issue, but the simple explanation is that I am this employee's granddaughter, but my mom was given up for adoption. Is this considered discrimination? Well, they didn't terminate you because of your family status. They terminated you because of a conflict, and the conflict just happened to be between people who are related. So family status, which is the only thing this could fall under, would be, you have a small child and you need to leave to pick that child up from daycare every day at 4:30, and then your employer says, we need you to work till 6 every day, and you say, I can't because I have to pick up my child from daycare, and they say you're fired. That would be discrimination on the basis of family status, depending on jurisdiction. It would be in BC, but certainly not in all jurisdictions. And I don't know if they have family status in all jurisdictions. And the fact pattern I just described, that being a family status implication, was only relatively recent, about 2 years, where that would have encompassed it. But in your case, I don't think it's discrimination. People don't get along in workplaces. As long as and so your employer can fire you without cause, which is probably what they did, provided that you are given sufficient notice or severance under the law. And if you weren't, it's called a wrongful dismissal. And so you should certainly look into that with a lawyer unless you've signed a release already, but you should look into that with a lawyer just to see that you got the right amount of money for your termination. Again, if you want to reach us, you can do so at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. But in terms of, apologies, you got terminated because of a conflict with a coworker who happens to be related to you. I can't see that being discrimination. I'm open to being incorrect about it, but that's just, at first blush, that's what my thought is. Sorry, discrimination on the basis of a human rights protected ground, which is what you need to get to anyway. Ellie asks, if your manager places you in suspension because you reported problems to human resources, is there anything you can do about it? I don't know the nature of the problems, but what you're telling me comes up an awful lot in employment law. There's no real good answer to this. So you, the employee, report something around your boss to human resources. Human resources is supposed to be a confidential space for employees to go about whatever issues exist internally. And then you're not supposed to suffer retaliation because you go to human resources, but human resources is there for the company's protection, not for yours. And certainly the confidentiality wall that's supposed to be there generally isn't, or it isn't quite often, especially if human resources has to investigate and talk to the manager, and if that's who you were complaining about. I will say this: if you said, I don't know what the complaint was, but if you said my manager is bullying and harassing me, and then human resources told the manager, and then the manager suspended you, that's the exact thing that human resources is that you were complaining about. So I would have to, if you were complaining about safety, that you may have a prohibited action there. I don't know what it's called in other jurisdictions in BC. If you're complaining about a safety issue, which harassment and bullying could be, and then they punish you for it, that's reprisal. That could be, you could have a remedy through occupational health and safety regime. You may have to actually report it first to the regime before you get the reprisal. I can't recall that, but you may have that there. But I'll just say, Ellie, that's a tough spot that you're in, because your manager doesn't like you now. It's probably impossible to save that relationship if your complaint was about your manager. I don't know how you solve it. It depends. Like, how long do you want to be there for? Is that a place? If you've been there for 20 years and you have to keep your job, is it something that you wouldn't mind moving on from and exploring? Severance possibilities. Does your contract allow them to suspend you? Could you claim constructive dismissal right now? You might be able to do that. And sorry, why you might be able to do that is if they suspended you without pay, they may have no right under your employment contract to do that, in which case you could claim constructive dismissal. Particularly because I don't know what the nature of the problem was, right? But if you reported this problem to to human resources and then you got suspended for it, I think at some point that just seems like they don't want to employ you anymore, and you can claim a constructive dismissal on top of the interruption of your pay. I just don't see how that's a viable relationship anymore, depending on what it is that you complained about, if it was about the manager, how that all worked. So, Ellie, I would talk to a lawyer right away. You can do so, again, with us at employmentlawyer.ca, help at employmentlawyer.ca, 1-855-821-5900. Okay, Layla asks, this is a good question. Layla asks, I don't think I have an employment contract at my job. Is this something I should be worried about? I've recently asked about it, and my employer keeps dodging my questions. Okay. This is a question I have to answer about every 4 to 6 months. And I'm going to say this as clearly as possible, and I want everyone to pay attention to this. Your employment contract, aside from, generally speaking, very high-level employees such as executives, C-suite executives like officers of the company, vice presidents, etc. Generally speaking, your employment contract is there for your employer's benefit, not for yours. Okay? You exchange your labor for money on an indefinite basis with other ancillary terms wrapped around it and wrapped around that relationship. And when you do those things for long enough, 3 years, let's say, all the terms of your employment all of those ancillary terms, in addition to pay, become an implied term of your contract of employment. And so if there's ever a situation where you have to make a claim against your employer, you're going to get all those terms implied into your contract of employment, even though you don't have an employment contract. You're going to have them all implied in, and so you're going to be able to pursue them in any legal remedies you're seeking. Okay. The primary purpose, in my opinion, of an employment contract is to limit the employee's rights upon termination. Okay. So if you have potentially 24 months coming to you, but you sign an employment contract with limiting language that limits your severance to the statutory minimums, which in that example would be 8 weeks, you've just lost 22 months of severance, which is a lot of money, depending on your situation, but usually it's a lot of money. So no, you don't want an employment contract. If your employer doesn't make you sign one, great. Never ask them about it, ever. It's good for you that you don't have one. If you're a rank and file employee, where you might want to, insist on an employment contract is if you have a lot of leverage. If you are a very in-demand, high-powered, high-level employee, like a chief operating officer or a sales executive of some sort, and you can negotiate your own terms of exit. Okay, but the percentage of the population that can do that is sub 2%. And anyway, those people are all going to have contracts anyway, because there's no relatively significant business that hires a C-suite level employee who doesn't have that employee sign, generally speaking, have that employee sign a contract. So no, you shouldn't ask your manager about it. If your manager is dodging your questions, great. Don't ask. And more importantly, Layla, if they ever say, because at some point they might go, oh, wait a second, we have all these liabilities or potential liabilities to our clients. Let's get them all in employment contracts. If your employer comes by and says, here, sign this employment contract, do not sign it until you get legal advice. And the legal advice will probably be, don't sign it. But there'll be certain risks if you don't sign it, and so a lawyer will apprise you of that. But don't bring it up. It's great that that your company is not making you sign one. Stop asking about it. It's entirely a good thing that you've never signed an employment contract, subject to whatever small, there might be some ancillary term that you want in a contract, but generally speaking, no. If you have any sort of doubt or confusion about that, speak to an employment lawyer right away. It is worth it, generally. I mean, if you've been there for 1 year, maybe not, but if you've been there for 20, absolutely, it's worth it. So if you need to talk to us, I'll give you the information at the end, but there you go, employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. But yeah, generally for everybody, don't sign. If they don't make you sign an employment contract, that's great. Never bring it up. Okay, question from Kylie. I worked for a nonprofit for the last 6 years, full-time position, but I was recently laid off as my employer listed me as a casual employee. I'm wondering how this will impact my EI or other entitlements. What should I do about this? Well, I think what you need. Okay, so first of all, laid off, and so the public uses laid off to mean termination, but that's not what it is. Termination is a termination where you no longer have your job. Layoff and you're not coming back. Layoff means it's a temporary or theoretically temporary interruption of your employment with the hope and expectation that you will be recalled to work. So it's the idea that the employer has a cash flow problem, and so we're just going to place some employees on layoff. That saves us money. They stay on layoff for 2 or 3 months, and then our cash flow picks up. We bring the employee back. We don't want to lose the employee, and the employee doesn't want to lose her job. That's what a layoff is. I don't know which one you're talking about, but I suspect it's the former. I think you've been terminated. Okay. I don't. Casual versus not is something that has to do with benefits. It doesn't impact your EI. Your hours worked is what impacts your EI, and your EI is going to be what it's going to be. As long as you were terminated without cause, you'll have an entitlement to EI, and Service Canada will sort that out with you based on how long you've worked since the last time you drew on EI. So Service Canada will sort that out with you in terms of the hours you've worked, and how many hours you've worked since the last time you drew on EI. So I wouldn't worry about that necessarily, but what you should do is examine whether, and I don't know if you've signed a release already, and this just goes for everybody, generally speaking, when you've been terminated, don't sign a release until you've talked to a lawyer. What a release is it's an exchange of value, usually money, for your signature on a piece of paper which says you can never sue or bring a claim against the company again for matters arising from your employment. You want to make sure that whatever they're offering you is commensurate with what you're entitled to at law. Okay, so what you're entitled to at law. So Kylie, you were there for 6 years. You should talk to an employment lawyer right away if you haven't already signed a release, and find out if you have a nice severance claim or not, if it's worth pursuing. I'll give the information at the end on how to get a hold of us. But yeah, you have to look into that. And then in terms of your EI question, I don't see any impact, but contact Service Canada. Just Google it. Service Canada's phone number is there. You can be on hold for a little bit, but you have to contact them anyway to get your EI going. So I don't know what this person's name is. If employer comparing mental health issues as the same, is that discrimination? I don't know what your question is. If employer comparing mental health issues as the same, I think there are some words missing from your question. I'll call you MB. If you could resend your question, I'll try to get to it before the end of the broadcast. Thanks. Okay, Alita asks, what would you say is the most common mistake people make when they find out they've been let go? So, I mean, generally speaking, your post-termination conduct has no impact on what you're entitled. So I'll just back up here a second. What I do for a living is I get people money after they've been terminated. Okay, and so I'm looking at it and that's what most people want. Sometimes people want an apology from their employer for the way they were treated. Sometimes people want a reinstatement, but 99% of the time we're talking about money. Okay, and people want the most amount of money they can get as fast as possible, and there's quite often compromises as both sides have their own objectives. So your post-termination conduct, generally speaking, isn't going to affect that. What affects it is your employment contract and your age, length of service, and position. The contract comes first, and then the other three. Okay. But there are certain things that an employee can do that can dramatically impact their severance, depending on the situation. One of them that I've seen come up, even though, again, their post-termination conduct shouldn't impact it, but I have seen it and have heard of it causing problems, is where an employee, particularly if there's a just cause allegation, where the employee deletes or wipes all of the data off their computer or company phone, so the company can't look at it, and so that data is the company's property. It can cause material harm to the company, and it can affect the credibility of the employee depending upon the nature of the allegation. So if you're terminated for just cause, for competing against your employer or for other reasons, and you quickly run back to your computer and delete everything, there isn't necessarily an implication in law, but your credibility before the court, if it ever got to that point, would be dramatically affected. So I would say that. I would also say, people work for businesses, and in today's modern economy, you're never going to work. Most people aren't going to work at where their employer until they retire. You move around, you have multiple different jobs, and the business is trying to run itself for its shareholders or stakeholders or owners or whatever. It has to make decisions within the economic framework that exists. And so, I would say, on the way out the door, take the high road if you can. Employers, if they are sympathetic to you, are much more likely to, I mean, not every case, but they're much more likely to be willing to reach some sort of monetary accommodation with you than if you're yelling at everyone on the way out the door, right? So I would just say take the high road on termination. I appreciated my time here, and you never know when you can come back. I've seen employees go back to their old jobs so many times. Thank you for employing me. I loved working here. You reconsider, or if things change and you're looking for someone again, please make me your first call. That goes a long way. So that would be my thought. But yeah, don't wipe away data. Generally speaking, unless there's I'll just say generally speaking. That's my comment on it. I'm not even going to say don't wipe away data. I'll say I've seen that affect credibility, and I'll leave it at that. But I don't, in any specific instance, this conversation we're having now is not a substitute for proper legal advice. And I would urge everyone to get that. Okay, we have one more question, and then we're done. Benny asks, terminated for performance, but all evaluations were under duress. Very stressful call center. I was an at-will employee. All right, so there's lots of things going on there. So there's no such thing in Canada as an at-will employee. You cannot be terminated. At-will just simply means, it's an American term, they can pay you zero upon termination or provide you no notice of termination. Can't do that. It's a violation of the law, and more than likely you'd be entitled to common law severance in that situation, depending on whether you're federally or provincially regulated. So that's number one. If you're terminated for performance, were you terminated for just cause, i.e. you were given zero? I mean, probably because you said you were an at-will employee. But if you were terminated for performance, to be terminated for just cause, which means zero severance, for performance, there has to be you have to be provided a clear warning of your performance failure and an opportunity to correct that failure. So it's your classic 3 written warnings and you're out. Okay, about the issue that was the problem. It can't be 3 different issues. Generally, it can be, but generally not. Okay, so were you provided that? That's something you need to find out. I don't understand what you mean by evaluations were under duress. Duress would be more like sign this employment contract or you're fired. That would be duress. Performance evaluations are a one-way street. I mean, even if the employer says, well, we want to hear what you have to say, they're a one-way street. The employer is evaluating your performance, not the other way around. So I don't know how that could be under duress. What would, and if you say it's a stressful environment, well, lots of work environments are stressful. That doesn't impact your entitlements under the law because it's a stressful environment. If it's an environment you can't tolerate working at, then don't work there, right? You can work somewhere else. You can always vote with your feet and go work somewhere else. But I would focus mostly on the at-will portion of what you were saying, okay? So I would go talk to Benny. I would go talk to an employment lawyer right away, and this is for everyone. I've said you should talk to an employment lawyer. If you want to talk to us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, at 1-855-821-5900. Okay, great. Thanks for all the questions. That was wonderful. It's a long weekend out here. I don't know if it's a long weekend everywhere else, but if it is, have a wonderful and safe long weekend. Join us on Tuesday on February 18th at 10 a.m. For a half an hour live chat session with Martin Willemps. Martin is a disability lawyer. It's for a disability law Q&A session. He's a disability lawyer par excellence. Join us for that if you have any questions about employment law. Guarantee you'll learn something. Martin is fantastic. Come join us then. You'll see me again in 2 weeks, regular time, 10:30. Have a wonderful and safe weekend.